around the world and across Nigeria. If you just joined us, you're still on to Enterprise Morning, reaching you from Enterprise Television. Now let's go to our main conversation for today. Nnamdi Kanu may not have as much as taken the first step to freedom following the outcome of Monday's proceedings at the Federal High Court in Abuja.
Justice Binta Nyako, the trial judge, rescued herself from the trial after Kanu expressed the loss of confidence in her handling of the case, citing the court's failure to obey Supreme Court orders.
Kanu, the leader of the proscribed indigenous people of Biafra IPOB, is facing a 7-count charge of terrorism brought by the federal government. During the trial, Kanu directly asked Justice Nyako to step down, stating that he had lost confidence in the court.
Kanu's request was prompted by the court's alleged disregard for a Supreme Court judgment that raised concerns about bias against him. The IPOB leader interrupted his own lawyer, Aloy Ejimako, and addressed the court, emphasizing that he understood if the Department of State Services DSS refused to obey a court order, but not the court itself.
And despite the prosecution counsel Adeboyega Awomolo's urging to proceed with the trial, Justice Nyako agreed to recuse herself, citing the defendant's lack of confidence in the court. Of course, to do justice to these and more very sensitive topic, if you ask me, we have joining us virtually from Abuja High Chief Peter Ame. Good morning to you, High Chief.
Good morning.
Good morning, High Chief.
Good morning, Nigeria.
Thank you so very much. And just to let you know that High Chief Peter Ame is the former chairman of Inter-Party Advisory Council. And with us also in the studios right about now is Barrister Damilola Kolawole. He is a barrister, law solicitor, and advocate of the Supreme Court of Nigeria. Good morning to you, Barrister.
Good morning.
Thank you for your time.
My name is Barrister Damola Kolawole.
Thank you very much for the correction. We truly do appreciate that. All right, so let's get into the crux of the matter right about now. And I would love to start by asking, Hi, Chief, are you still with us? I think we have some technical glitch there, but let's start with you, okay, Barrister. Tell us more. This is your field of forte. Bring us up to speed, if you may, most importantly, on the recusal of the judge.
Well, it's important that we'll understand that the issue of subjectiveness, when it comes into justice, then it seems more or less like justice cannot be attained. You see, the end product of whatever judicial process you want to actually undertake is the end product of justice. And when a particular judicial officer is tainted within the context of the word biasness, it means that there is this cognitive understanding of the fact that whatever justice that is delivered in that context will not be justice to be seen as justice being achieved. And we should know that there are plethora of maxims that actually support that. If you look at the principle of natural justice itself, or the altering partem, here the other party, nemo judes in casual, you can't be a judge in your own case. It means that in any form that there's a judicial process, and the judicial process for one reason or the other is tainted with cultural bias, with religious bias. It could even be a bias in affinity. It means that the judicial officer is seen to be one way or the other affiliated. It could be in relationship with a party in a suit. It means the judge definitely should actually attain some level of professionalism by recusing itself from such a matter, because the end product of that matter will not be justice to be seen as being attained.
Thank you, Barrister Damola. Hi, Chief Peter, are you there? Can you hear me?
Yeah, I can.
Okay,
I can hear you.
Now looking at the situation on the ground, how does this situation bring Nnamdi Kanu closer to justice? Because of course he wants to get justice.
Yeah, he wants to get justice, but the fact that
I think we're having a bit of difficulty.
Hello?
Yes, okay, we can get you.
He's not being honored shows that it is because one thing about justice, if the will of justice grants too slow, it might even deny you the necessary justice at the end, even if you get what you are looking for. Because if a man is incarceration, if his jail term is supposed to last be 10 years, and the man has spent 10 years in prison, to what extent has he got injustice? So for one of the things he's asking for, and that there's a tendency for bias, that there's a tendency, so every Nigerian citizen that find out that court is not acting the right, they can also file such application or make such statement that they do not believe in the impartiality of the judge that's before them. So I think that the court must act differently, because the freedom of every human being until proven guilty is very fundamental within a democratic setting. And I think it's within his right to seek such right within the court. And the security agencies that are holding on to him, who have claimed that he has committed treason, should quickly come up with the necessary evidence that is available so that this trial can go on, so that Nigeria can be at peace. You know, the Kanu issue is an issue of it's fundamental right. And yes, we know that right has an extent in
Okay, thank you, High Chief. Barrister Dami, you are a barrister. Now, I want to actually quote Nnamdi Kanu here.
He said, people that people that pride themselves that we are running a democratic government, and that democracy gives a lot of fundamental right to our citizens. We see a lot of people who have committed heinous crime, who have committed crime against the state when it comes to banditry, terrorism in the north and all that, and there's this rehabilitation. I think sometimes some of these discussions that we're having with the issue of Nnamdi Kanu is for us to probably sit down, because some of these things can be done with dialogue. We can dialogue with Boko Haram, we can dialogue with banditry, we dialogue with Ijaw militant group, Niger Delta militant group, I withdraw that statement. Niger Delta militant, when the Niger Delta was unstable, I don't see why the issue of Nnamdi Kanu has become an extreme case that is beyond the issue of reasoning. That people can sit down on the table and ask him what to be done, what should be done, and how this thing should be done. He has said himself on occasion that they are open to dialogue, and this dialogue should be the best route, because when we judge up, we can easily find solutions to issues than when we war, you know, because there are different regions within this country. So the Bow case is there. Bow is having his freedom today and enjoying that freedom within this Nigerian territory. And I think the case of Nnamdi Kanu should not be different. If people speak, they say, oh, if people speak, it's not about tribe. I'm an Igala man from Kogi State. I just feel that citizens of this country must have equal treatment across board, must be given equal fair sense of belonging, and for us to do proper integration of people who have a grave interest is most times done on the round table when dialogue is a factor that brings peace.
Okay, thank you, High Chief. Thank you. Sadami, I was getting to you, and now I want to quote Nnamdi Kanu saying, I can understand if the DSS refused to obey a court order, but for this court to refuse to obey an order of the Supreme Court is regrettable. Should we have gotten to the point where Nnamdi Kanu now had to point out to the judge that they are refusing to obey the Supreme Court order for her to step down?
It is absolutely not appropriate for us to say that it is, when the DSS disobey the court order, that is not the rule of law. That is not the propagation of avidice. You see, the rule of law is law, even the governments that are the custodian of the law, or even the lawyers and the judiciary that are locus parentis, to the law, themselves must be accountable to the law. So the rule of law is clear about that statement. That statement is absolutely not in place. You see, and if we look at it very well, we will understand that the issue of separation of power also comes into it. The postulation of Baron de Montesquieu, when it talks about, the right of the executive, the right of the legislature, and the right of the judiciary. In context of that, we know quite well that all the apparatus of the security agencies are in the hands of the executive. But all the same, it will not be appropriate for us to say that, a party that is interested in, secession in the country should not be checkmated. Because look, if you look at, yes, he has his fundamental right and the right to fair trial, as enshrined in section 36 of the Constitution. But also you should understand that there's a derogatory right in section 45. When you're right, you know, when you have all the rights, you know, to section 37, section 35, section 34, you should understand that your right is limited in section 45. When issues becomes a threat to the state or public policy, when your right is infringing on the general right of other persons, your right is limited by section 45. And that is where it comes in. But all the same, the right in section 36 to fair hearing must be guaranteed. And that is what a lot of persons have been saying, that look, you cannot hold him in perpetuity. You have to obey the rule of the law. You have to obey the rule of the court. You have to obey the pronouncement of the court. And you see, if you look at Oliver Wendell's postulation, the ruling of the court, the statement of the court itself is law.
Now, in all of this, why? Because the judiciary are actually meant, their basic responsibility is interpreting the law, just like you finally done here. Now, why does it now make it a bit difficult for the arm of the law, responsible for interpreting the law, finding it even difficult to understand the law they are supposed to interpret in the first place?
Now, you see, look, the judicial system we practice in Nigeria now, because we are actually bringing in comparative understanding. The judicial system we practice in Nigeria, for one reason or the other, had been political and not apolitical. You see? So when you look at section 4, section 5, and section 6 of the Constitution, if I analyze a bit to you, you would understand that I should be a locus parentis to the Constitution and not against the institution where I belong to. But I will explain a bit. Yeah. Section 4, section 5, and section 6 of the Constitution of the Federal Republic of Nigeria as amended. You should see that section 4 is the authority to the legislature, while section 5 is the authority to the executive arm of government. Section 6 is the authority to the judiciary. But look, it is funny that you will understand that section 5 of the Constitution appoints section 6 of the Constitution for the confirmation of section 4 of the Constitution. And that is where we find ourselves. You should now understand that in the context of that, he who pays the piper dictates the tune. He who pays the piper, in the context of the fact that section 5 who appoints section 6 and to the confirmation of section 4 dictates what section 6 decides. Which is an abnormality. Well, you will say that, you can say that again. It remains an abnormality. Look, you see, that is the reason why you are talking about, independence of the judiciary. And I ask the question, how is the judiciary going to be independent? Nemo that called on that bit. Can you beat something or nothing?
Awesome. Hi, Chief. That's a very big one, but I'd love you to speak to that. Barrister just talked about independence of the judiciary, a situation where every case looks like a felony. Everyone that's brought to the court is labeled, had to have committed all of this. Remember the hashtag End Bad Governance. Protesters that were brought to the court and felony was labeled against them. How do you think we can get out of this quagmire, a situation where, of course, there is no longer independence in the judiciary? Can you unmute if you may?
My brother there has spoken very well. Yeah. In regards to fundamental human rights, whether section 39, section 40, section 41. But he has also talked about section 41, 45, which restrict the fundamental right to a greater extent. But we are not talking about succession here. I'm not talking about people trying to leave this country. I've seen worst case scenario with the Boko Haram, who take lives, who bomb churches, who bomb mosques, who kills innocent Nigerians. I still got a fair dialogue on the table. We are talking about a decision that for us to keep a country one, we must be able to listen to ourselves. And for the court must be able to dispense justice as much as possible. The court, if you remember growing up, they'll tell us the court is the last hope of the common man. Even in the worst case scenario in the dictatorship, when we had military regimes, the court was not touched. The National Assembly will be abrogated. The NUC, STLC, everything abrogated by the military regime. But the court were left to continue to function in whatever semi-quasi state they found themselves. But what I'm saying is that today we're in a democratic system, and the court being the only temple where we could have gone to balance what the situation, whether the executive or the judiciary is doing, the executive or legislators are doing in our abnormal style. What we now have is a situation where there's executive interference in the court system. And these are facts. A lot of senior lawyers have said it from years to protect, but a lot of senior lawyers have seen how the court has blinded closed its eye to the unwanted destruction of life and property either by security agencies, decisions that are taken by corrupt senior officials, and they go scot-free. And yet, peaceful protesters that are unarmed, that have no weapon, that have nothing to destroy anything, are being tried for treason. And yet, the court has put in very stringent measures, for them to get their bail. So this situation is a situation that we must look properly and then decide to look for a way. If we say that the national NJC, the NJC should be responsible for the appointment, recruitment of judges, and then forwarding the name to the National Assembly, we will not be doing anything that is abnormal. In every democracy, you must define your own principles and your own operation. Because we have found out that this appointed authority, who are bidding 40 courts and who will announce politically, and the way they do it by increasing salary of judges by 300%, the way they do it by building 40 houses for judges, this undermines the integrity of the judicial system. And for us to get it right, we must free them from the winter caprices of politicians, so that these people who are supposed to sit on the temple of justice will dispense justice without any sense of favor, without any sense of fear. We have seen when justice is said that you cannot get appointed to the appeal court when a judge was making a statement in a public, and so they attacked her and said, look at the kind of judgment you gave me, look at what you gave to me, the kind of bail condition you gave to me, because you were working for government and you got promoted to court of appeal. This is not good for our judicial system. Our judicial system must be above board. They are the only hope we should have in a democratic society to free us from the draconian dictatorial tendencies of any democratic leader who wants to overturn justice. So we have a problem in the country now, where even the ordinary citizens in the country, when you say go to court, they run away because they are afraid that go to court means go and lose to government, go and lose to powerful entities, and go there and not get justice. But I believe in the judicial system, and I know that somehow it will self-cleanse himself, because I have been a beneficiary of the system in a lot of ways, even when government stuff. But I know that there are bad decisions that have been taken today that have its own influence. And we must also see how such influence have affected our electoral system, that's affected our democratic practice, that's affected our freedom to freely hear our voice and practice. Our court system must be re-established on the basis of freedom. And he said, they made a statement that said, when the court statement, the court declaration is a law, so it's a law itself. And that should be the case in our society, since we are running democracy currently. But we have a problem with our court, and our court must be cleansed, must be given that necessary judicial independence to get it at direct life charge. Look at what the president did when Kekere, which is an automatic elevation based on the rules and regulations of what happened in the judiciary, that when the most senior justice we have elevated to active capacity at the Supreme Court, President Tinubu, maybe not knowing the modus operandi, went and sworn her in. When you are supposed to swear her in, maybe after it has been confirmed by the National Assembly. So we have a problem where politicians are dipping their hand into this system and they are spoiling it. I believe that a lot of lawyers like my brother that are there, they must rise up to do whatever is possible. We will continue to speak from the layman point of view and then continue to decide to discuss with them so that they can rise up and make sure that the judiciary continue to remain the only place that the common man can run to, the only place that we can seek justice. Because whatever is against Nnamdi Kanu today are still on the basis of allegation, until proven beyond reasonable doubt in the court of law. So we cannot now continue to say that, oh, somebody called for those who are stealing our people, who are making sure that ordinary man cannot get healthcare in public education in public schools. I went to a baby college free of charge. Who are making sure that people cannot have public transport system that is cheap, that can convey the child of the poor man to school. Who are making sure that people cannot get any opportunity. There's no public library that is functioning. I enjoyed it. I saw it in my lifetime in this country. So what are we saying? What is the punishment for those people? How many of these people have a system? Why is their own justice so slow on that part and so fast on the other side? So we must just oppose this issue and look at it analytically and decide to say, yes, if justice must be dispensed, everybody must be equal before the law, and there must not be favoritism in the side of trying to manage the system. Well, I talked about Sunday who is there. I talked about a lot of people who are in the north who have enjoyed peace. So we are saying that, yes, if Nnamdi Kanu is guilty, let the court fasten the trial and find him guilty. But if he's not guilty, let them also fasten the trial and grant the man a freedom to his life, which is his fundamental right, both from God and the Constitution of the Federal Republic of Nigeria. And if he has anything to do that he must be castrated for that period of time throughout his trial, then I don't know. I'm just looking at it from a human point of view.
All right. Thank you so very much.
Bagsagami, he made some strategic comments, like he made some pinpoints, and one of it I held on to is the court is supposed to be the hope of the common man. And at this point, looking at our country, Nigeria, how do we get to that point where the courts will become the hope of the common man? Because it is now as though the politicians and the bourgeoisies are now those that have the hope of the courts.
I said something earlier. Thank you very much. I said something earlier, and I'm going to actually repeat that statement. It is a fact, you know, it is not just the truth, because the facts, we say it's empirical. We must understand the fact that when something is constitutional, there is the least that you can do, the law is clear. The appointer of the Chief Justice of Nigeria is the executive arm of government, and the confirmation to that appointment is the legislative arm of government, and that is Section 5, appointing Section 6 for the confirmation of Section 4. Now, let's go back to this. The Chief Justice of Nigeria is the chairman, National Judicial Council. That's one. The Chief Justice of Nigeria is the chairman, Legal Practitioners Disciplinary Committee. That's two. The Chief Justice of Nigeria is also the chairman, Legal Practitioners Privileged Council. That's three. The Chief Justice of Nigeria is the chairman, National Judicial Institute. That's four. The Chief Justice of Nigeria is the Chief Justice of Nigeria that holds all the machinery of the system of justice in Nigeria. And that Chief Justice of Nigeria, like I said, is an appointee of the executive arm of government. Please, the payer of the piper, who is the piper? What right has the piper to only go on his own route of judicial activism? If the piper, in the Nigeria context that we have today, look, my brother said something. It will not be appropriate for us to follow the route of autocratic system. It will not be appropriate for us to follow that totalitarian system. It will not be right for us to follow the despotic system that we used to know in the military era. But can you see that even in the military era, there are some, you know, like he said earlier, there are some areas that you give even the judiciary the opportunity to perform their responsibility and responsiveness to the generality of Nigerians. But now, what do you have? A judge cannot make any unilateral or following the activism route of what we call judicial activism anymore, because you are going to be questioned. Who gave you the order? Must a judicial officer be given an order? The order must be given by what? The Constitution. But that's not what we have now. You see, so you can see the law being interpreted to suit the whims and caprices of the bigs and mighty. That is what you have in Nigeria now. It means that an ordinary person who steals something of 50,000 naira could go to jail for 5 years, while the big man that steals a 50 billion in Nigeria could have a plea bargain. That is the principle of law, being interpreted to suit the whims and caprices of the big and mighty. Now you can see the dichotomy. And look, when you follow the Pareto's understanding of circulation of elite, you will also understand that the Pareto himself actually created the segregation between classes. That look, for us to be able to say that there are classes in every society, that the haves, who do we call the haves? The bourgeoisies, and the haves not, the proletariat. You understand? That is the me and you. You understand? So the idea is, when you talk about the classes in the country, the classes has something to do with the means and manner by which you interpret the constitution. Because you are going to be interpreting the constitution against the proletariat and the constitution in favor of what? The bourgeoisies. That's the system we practice. But look, in the Senate crime, because now we say the system we are practicing, like we are practicing a presidential system. Is the presidential system we practice, is it in similar fact to the presidential system we inherited from the Americans? Is democracy in America the same as democracy in Nigeria? The answer is no. When you could want to prosecute the president of the former president of the United States of America, can you try that in Nigeria? It's almost impossible. You see, so we are evolving. And I believe in the context of the fact that we are evolving, someday we'll have a political leader that has the political will to want to stand his ground and follow the due process of the Constitution, or define our Constitution for us to have an autonomous Constitution. Because what we even have as a foundational Constitution that we practice, from the Clifford Constitution to the Richards Constitution to the Matheson Constitution to the Lightington Constitution to the Hugo Willis Commission, heralding the Independence Constitution till today, is not a constitution of our own making. And by so doing, the colonizers gave us the foundation of the constitution we practice today and gave it in the hands of the elite. The elitist theory also absorbed the constitution of the colonizers and use it against the generality of the people.
So how do we break away from this chain? How do we break away from all of this? You
will go back to the Nigerian state and the name of the Nigerian state. And who gave you the name of the Nigerian state? A prostitute gave you the name of the Nigerian state, of the Nigerian state you are inheriting today. So you go back to the foundation of the Nigerian state and try to look at it from, look, our oneness must be properly addressed, because the amalgamation of 1914, the marriage of convenience, the mistake of 1914, because you must look at, look, how do we bring about that paradox of unity within the diversity that we are? You must have to look at it, because for us, for you to marry a wife, there must be a consensus at the there. There must be a meeting of a center. You must agree. Because if you don't agree, there will be a continuity, infinitum disagreement, which one day the center will not hold.
Beautiful. High Chief, just before we drop our anchor for today, I think it's very important we bring ourselves back to what we had, kicking off our main conversation for today, and looking at the recusal by Binta Yaku, and saying that she's no longer interested, and of course saying that the Chief Judge would further decide who would take over the case going forward. What make us feel that there wouldn't be same vicious cycle in the whole case at the end of the day? Do you think it's possible to have a judge that would better do a good enough job?
It is for me. I do not. I'm not expecting anything to come out of this because of the way the security.
Are you still with us, Hi Chief? I think we're having some network issue there, and so if you may.
The question you asked is, definitely you should understand that the judge that had, accepted to recuse, itself from the matter will actually send the case file back to the CJN, who decides, another judge to actually handle the matter. But you should understand that there's an executive influence and there's executive interest in the matter. So whosoever is going to eventually handle the matter again will want to be very careful in context of the fact that, you see, you will be in office today, but tomorrow you will not be in office. And then there's what we call stare decisis. Precedents take after. Because your name, in whatever decision, in whatever pronouncement made by you, your name is attached to that pronouncement, and it becomes a precedent to be followed. So a lot of justices will decide in context that they want their name to be embellished in such manner, and some will decide that, look, for my personality, for my family, for my future, for my interest, I am recusing myself from this matter. I am not interested in it. Because, look, a whole lot of misdemeanor that you can see in Nigeria today, lots of those misdemeanor one day will be looked into. And you cannot shy away from what has been done. If what has been done is permanent, if it is in black and white, if it's an express understanding, there's no way you can shy away from it. So a lot of persons will decide that, look, instead of being part of this abnormality, of this illegality, of this unconstitutionality, I don't want to be a part of it. And other persons might see, oh, for one reason or the other, I've represented you or represented what you believed in. For the reason that I've represented you before, there's an affinity. And the affinity might result cumulatively into impartiality. For the reason that I would rather recuse myself. Other persons will say culturally, and other persons will say religiosity. So there are so many reasons why a judge will want to actually recuse him or herself from a matter of this sensitive, nature. Because the matter that has to do with sections, the matter that has to do with a part of Nigeria is a matter that is highly sensitive. So that it does not come in the next 40 years and somebody is telling you a story that it was your grandfather that did this to our region, and so you cannot have this, and that. So look, we have to be very careful. This is highly sensitive, and whatever you do now, all that is done now will be revisited in due time.
Very apt, very so apt. But we can't say thank you enough, Barrister Dami, for this incisive discussion. We truly do appreciate it.
Thank you very much for having me.
And also we had to let High Chief Peter Ame leave, unfortunately, because of a technical glitch that we had, and of course we have to say
technical glitch.
Yes, that we have. Love to say thank you to High Chief Peter Ame. Thank you so very much. We truly do appreciate your time whenever we do call. And most importantly, we love to say thank you to you. You've streamed, you've watched, wherever it is you've done that around the world. We love to say thank you to you. We truly do appreciate the time and promise to never take you for granted. But please do well to be part of our tribe and join our community by visiting us whenever you do. Like at enterprise.tvnews.com, and also like, comment respectfully, that is, and follow us on all our social media platforms at Enterprise TV7. I am Henry.
And I'm Choma Okoye.
On behalf of the entire team of Enterprise Television, thank you once more, and we'll see you tomorrow.
Bye.
Bye-bye.